Thank you very much, Mr. Speaker. And Mr. Speaker, with your leave, I rise to have read a second time the bill shortly entitled the Electronic Communications Bill 2020. Mr. Speaker, telecommunications, or in particular electronic communications, has grown to become one of the essential means of communication, as we have witnessed over the past year. And this form of communication, Mr. Speaker, has evolved over the years. Mr. Speaker, our current Telecommunications Act, with its suite of regulations, which were enacted over some 20 years ago, requires legislative reform. Mr. Speaker, the Eastern Caribbean Telecommunications Authority was established on the 4th of May, 2020 in St. George's, Grenada, as the regulatory authority for the telecommunications sector for 5 contracting states of the Organization of the Eastern Caribbean. These states are the Commonwealth of Dominica, Grenada, St. Lucia, St. Vincent and the Grenadines, and the St. Kitts and Nevis. Mr. Speaker, in the Federation, the national implementing legislation which recognizes the treaty is the Eastern Caribbean Telecommunications Authority Act, which incorporates the provisions of the treaty into domestic law. Since the establishment of ECTEL and the enactment of the telecommunications legislation, the Telecommunications Act and accompanying regulations that have been in existence for over 20 years, there have been some significant growth and development in the sector, which necessitated a reform of the legislative framework. Mr. Speaker, just to provide a bit of background as it relates to this particular bill, the first step in the process was to prepare the protocol amending the ECTEL Treaty, which revised provisions for the treaty with the addition of new definitions and removal of old definitions, which are no longer required in order to prepare for the introduction of this EC bill. Mr. Speaker, that amendment ensures that ECTEL continues to maintain its obligation under the treaty as well as international obligations in relation to the regulation of electronic communications. ECTEL commenced the amendment of the ECTEL Treaty by ensuring that its contracting states signed the protocol and thereafter signing and submitting the ratification instrument, which were deposited to the OECS Commission as required in advance of the remaining phases of the legislative reform. Mr. Speaker, I am pleased to announce that the Federation has indeed signed the protocol instrument, and the former minister would have been the one responsible on the 23rd of October 2018 and signed the ratification instrument on the 11th January 2019, which were deposited at the OECS Commission on 28th January 2019. All ratification instruments of the protocol amending the ECTEL Treaty from each of the 5 contracting states have been deposited at the OECS Commission. Consequently, the OECS Commission, as depository of the ECTEL Treaty, has notified that the protocol amending the ECTEL Treaty is in force as of the 5th of December 2019. Accordingly, as at that date, all 5 member states were in a position to pass into law the Electronic Communications Bill and its accompanying regulations. Mr. Speaker, I wish to provide a synopsis on the lengthy consultative process taken on the EC Bill. In 2009, ECTEL commenced the process of a series of extensive and in-depth public consultations in all ECTEL contracting states before the bill was drafted. A consultation was conducted to ensure the maximum possible opportunities for comments and concerns about potential changes to the telecommunications legislative framework from telecommunication providers, radio and TV broadcasters, the public at large, ministers of telecommunications, and NTRCs, among others. The consultation was also conducted to give stakeholders a chance to comment and contribute to the development of the draft EC Bill. ECTEL conducted a number of public consultations and published public notices on its website and the websites of the National Telecommunications Regulatory Commissions in preparation for the legislative reform in the sector. This provided opportunities for all stakeholders to review and comment on the EC Bill and the regulations. Various media outlets were also used to raise awareness of the legal reform of the sector. There were a number of roadshows and presentations to various stakeholders in each ECTEL contracting states to promote the EC Bill. At the end of the consultation period, a drafting consultant was engaged by ECTEL to review the representations arising from the consultation and to draft the EC Bill. This exercise, Mr. Speaker, was completed in November of 2012. The initial draft EC Bill was presented to the Council of Ministers at their 27th meeting, dated the 12th of March 2013, for review and approval. The Council proposed that the draft EC Bill be reviewed by the legislative drafters of the ECTEL contracting states, after which it should be laid before the Legal Affairs Committee of the Organization of Eastern Caribbean States. Once approved by the Council of Ministers, ECTEL submitted the final version of the EC Bill to its contracting states on 13 September 2019 for presentations to the respective Cabinet of Ministers of the governments for approval before presentation to Parliament. In October 2019, ECTEL would have made a cabinet presentation to the administration of St. Kitts and Nevis, and on 28 November 2019, the bill commenced its first reading in Parliament. Subsequent to that, we would have our dissolution of Parliament and the forming of the new government, and therefore it required us to resubmit to the new Parliament for its first reading, which happened on the 13th of August 2020. Mr. Speaker, I will now turn to the details of the EC Bill and provide this House a synopsis of its objectives. Mr. Speaker, the enactment of the EC Bill in the Federation of St. Kitts and Nevis will ensure a broader scope of regulations from telecommunications to electronic communications, and will also address matters, but not limited to, principles of fair competition, change of ownership of electronic communication companies with the ECTEL contracting states, universal service and access, preservation of an open internet with the adoption of net neutrality principles, the establishment of the NTRC as body corporates, the setting up of a tribunal independent of the NTRC to hear unresolved disputes between licensees and customers, and the inclusion of more penalties for breach of the legislation, among other things. Mr. Speaker, the EC bill includes the critical elements necessary for an effective regulatory framework, such as the functional aspects of the regulatory authority, decision-making processes, accountability, consumer protection, dispute resolution, and enforcement powers. Mr. Speaker, the EC bill will serve as a valuable piece of legislation for the electronic communications sector in the Federation of St. Kitts and Nevis, because the goals of the EC bill are to ensure that market failure is avoided, to foster effective competition, and most important, in my opinion, is to protect consumer interests and to increase access to technology and services. And I believe even now, as we move towards a digital economy, this means so much more in light of that, Mr. Speaker. Mr. Speaker, the reforms proposed in the EC bill are intended to give the regulatory authorities new tools required to address significant changes in the electronic communications sector. Since the promulgation of the Telecommunications Act over 20 years ago, the most notable of these changes are as follows. 1, market consolidation. Mr. Speaker, in the past 5 years, there have been a number of mergers and acquisitions in the electronic communications sector. The most recent and far-reaching is the merger of the parent companies of Cable and Wireless and Columbus Communications in some of the ECTEL contracting states. The result of this merger is that in Grenada, St. Lucia, and St. Vincent and the Grenadines, the island-wide fixed network infrastructure is now owned and operated by one operator, creating a near monopoly in fixed voice, broadband, and video services. Under the current Telecommunications Act, the Minister and the NTRC have very limited power to review, change of ownership licensed service providers, or to impose any conditions on the merging entities. The EC bill proposes significant competition rules, which provides the Minister and NTRC clear powers to regulate the change of ownership or changes in significant shareholding. In addition, the EC bill provides clear and transparent rules for how a license would be determined as having significant market power and sets out the obligations that can be imposed on significant market power service providers. The EC bill also prohibits anti-competitive behavior by all licensees. 2, vertically integrated operators. Mr. Speaker, market consolidation in the electronic communications sector has also resulted in vertically integrated licensees. And this simply means, Mr. Speaker, that the same licensee provides services at every point of the value chain in the electronic communications sector. The major service providers who control access to submarine cable systems also control terrestrial-based fixed and mobile services, infrastructure, and also provides retail services to customers. And I think we know examples of that, Mr. Speaker. Access to subsea and land-based infrastructure is essential for a vibrant and competitive electronic communications market. However, vertically integrated operators have no incentive to compete with them in the retail market and increase choice to customers. Lack of access to essential infrastructure is a significant barrier to entry in the market. The EC bill includes clear provisions which will allow the NTRC to determine when and how vertically integrated operators are to provide access to essential infrastructure, thereby eliminating bottlenecks and barriers to entry and enabling competition in the electronic communications market. 3, consumer protection and quality of service. Mr. Speaker, the current Telecommunications Act is silent on the very important issue of consumer protection. This means that the NTRC have very limited ability to impose obligations on licensees related to the terms and conditions under which they provide service to consumers. Currently, the vertically integrated service providers have a very poor reputation for consumer protection and quality of service. The EC bill includes clear powers for the NTRC to regulate the terms and conditions under which service is provided to the public to ensure fair offerings and quality of service to consumers. It will also allow customers to lodge complaints online against the service providers. And so to the general public, this bill allows you, if you feel as if your service provider is doing you an injustice in terms of your service, be it mobile, fixed line, broadband, whatever it is, you can complain to the NTRC and have your issues rectified via the NTRC. 4, enhanced powers of the NTRC. Mr. Speaker, the EC bill also addresses other issues, including providing the NTRC the ability to change their structure to a body corporate, which gives them legal personality, and as a result, enhances their role and powers by granting them specific authority to acquire property in its own name, sets out clearly the funding arrangement for the NTRC, and to promote transparency. Mr. Speaker, penalties. A rule is ineffective if there are no penalties for its breach. And therefore, Mr. Speaker, the EC bill augments the provision on offences for non-compliance with the legislation and allows for fixed administrative fines in some instances. And finally, Mr. Speaker, compliance with treaty obligations. Mr. Speaker, the treaty was amended by protocol, which was ratified by all of the ECTEL contracting states, with heads of governments depositing the ratification instruments at the OECS Commission. The amended treaty, along with the EC bill, ensures that ECTEL maintains its obligations under the Treaty of 4th May 2000 and its international obligations in relation to telecommunications regulation, namely, 1, to promote fair and efficient market conduct and sustainable competition between electronic communication providers. 2, to encourage, promote, and facilitate, and otherwise assist in the establishment, development, and expansion of the electronic telecommunications sector of contracting states, Mr. Speaker, which we have found in these COVID-19 times to be proven to be very essential. 3, to establish licensing systems that are responsive to the changes within the electronic communications sector. 4, recommend effective regulation of prices, terms, and conditions for the provision of electronic communication and broadcasting services. And finally, 5, to improve the effective and efficient use of spectrum. And I know we've heard a lot about spectrum, especially as it relates to the ham radio and SCELEC issue, which is being addressed, as we would have said numerous times. Structure and contents of the EC bill, Mr. Speaker. Mr. Speaker, the following is an outline of the EC bill, which demonstrates how it has enhanced the Telecommunications Act. In part 1 of the bill, Mr. Speaker, The Telecommunication Act has been expanded in this EC bill to include definitions that were not included previously, such as definitions for electronic communications, net neutrality, and reasonable network management, and the expansion of some definitions, such as the definition for universal service to universal service and access. Part 2, Mr. Speaker, speaks to powers and duties of the minister. Mr. Speaker, this section was retained, which gives the minister the power to pass regulation relating to the legislation. Part 3, the National Telecommunications Regulatory Commission. Mr. Speaker, under this part of the EC bill, the NTRC is to be a body corporate with authority to contract, to sue, and to be sued in their own name and to hold property. Under the Telecommunications Act, the NTRC is a statutory body. The areas of expertise required to serve as a commissioner has been expanded to include knowledge of competition, project management, business administration, and regulatory experience, amongst other things. Mr. Speaker, this part of the EC bill also makes an allowance for the use of ad hoc advisory committees by the Commission. It also sets the ground for dismissal of commissioners, introduces rules for secrecy and confidentiality, sets rules in relation to the submission of budgets and work plans, exempts the Commission from taxes and levies. The EC bill strengthens the accountability of the Commission in respect of financial matters, including audits, and clarifies the responsibility of the commissioners in cases of conflict of interest. It also expands the scope of possible exemptions from the Act to include exemptions from licensing for health and public safety services, and for the first time grants authority to the minister to exempt certain recognized entities like health and fire services from having to pay fees associated with spectrum authorization. The EC bill makes provision for the NTRC to contract with a private entity to manage the top-level country domain name, and for the Commission to issue codes of practice, breaches of which constitute breaches of the terms of license. Mr. Speaker, Part 4 of the bill, which speaks to licensing authorization of electronic communications, sets out a clear and detailed procedure for the application, review, and grant of licenses, and removes this process from the regulations, incorporating them into the draft bill. It increases the term of special licenses from 10 days to 21 days, and it sets a penalty of $1 million for breaching country code top-level domain name registration. Mr. Speaker, Part 5 of this bill, change of control and ownership of licenses and frequency authorizations. Mr. Speaker, the EC bill sets out new provisions and a procedure to deal with the change of control and ownership of the license and frequency authorizations. It requires notification for change of significant interest, defined as ownership of more than 20%. It also sets restrictions on change of control of a licensee which did not exist under the Telecommunications Act. A certificate of non-objection is now required from the minister. Mr. Speaker, Part 6, rights and obligations of licensees and frequency authorization holders. Mr. Speaker, this part of the bill relates to rights and obligations of license and frequency authorization holders, and it includes very important provision which provides the NTRCs with new tools necessary to address the emergence of vertically integrated service providers. This part of the EC bill also includes clear provisions which will allow the NTRCs to determine when and how vertically integrated operators are to provide access to essential infrastructure, thereby eliminating the bottlenecks and barriers to the market entry, as I would have said earlier, and to enable competition in the electronic communication market. And I hope some entrepreneurs are listening carefully, because this is an opportunity now for them to be able to get into this electronic communication market. Mr. Speaker, this part also introduces new obligations of licensees related to consumer protection, number portability, allowing you to move your number from service provider to service provider without actually losing it. So once ago, and it's already started, once ago you knew 662 was one company and 7 whatever was another company. Now you're allowed to move your number in between the service providers to allow you the opportunity to decide. If you're not satisfied one place, you can easily move to another without losing that identity of your phone number. Mr. Speaker, Part 7, registration and approval. This part addresses country code level domain and type approvals. Part 8, competition. And this is where I want persons to listen carefully. The EC bill addresses the regulation of competition under this part. This part of the EC bill introduces new provisions to allow NTRCs to address concerns raised by market consolidation and the rise of service providers with significant market power. It provides clear and transparent rules for how a licensee would be determined as having SMP, or that's significant market power, and the obligations that can be imposed on service providers. It prohibits anti-competitive conduct, such as agreements between licensees and concerted practices which have the objective or effect of restricting, preventing, or distorting competition within a contracting state. With the new development of the OECS Commission, that the OECS Commission will not be establishing an OECS competition body for its member states to manage and regulate competition issues, ECTEL will receive all applicants for assessment and determination. The intention in the future is for a competition mechanism to be established with support from CARICOM, Competition Commission for OECS member states under the revised Treaty of Chaguaramas. Part 5, Universal Service and Access Fund Service. I like this part. The EC bill addresses universal service and access under this part and extends the definition of universal service to universal service and access, and allows the USAF to be used to provide access devices and other services in support of universal service. In addition, the fund can now be used to support ICT, entrepreneurship, and local content development through grants. The fund can now be used by ICT to support ICT entrepreneurship, our young entrepreneurs who are interested in IT, technology, and technology development. And if you have graphic designs or computer businesses, whatever it is within the technology space, you now have a source where you can go to assist you with granting or funding that you may need to start that business under the Universal Service and Access Fund provided through ECTEL by our local NTRC. So I would encourage all of our young entrepreneurs, especially those within the technology space, to go to the NTRC and find out more information. And they're located in Fort Lands. Find out more information on how you can access those funds to be able to help you to start start that IT business that you've always wanted to start. 10. Other offenses. The EC bill addresses other offenses under this section. These offenses were present in the Telecommunications Act, but did not have penalties attached. For example, the connection of equipment onto a telecommunications network now carries a penalty of a fine not exceeding $10,000 or 2 years imprisonment. Part 11, investigation. The investigation of breaches by the Commission has been set aside as a specific section under the EC bill, rather than within the body of Part 2, Section 16 of the Telecommunications Act. Part 12, dispute resolutions. This section empowers the NTRC to intervene in disputes which remain unresolved between retail customers and the providers after 30 days, and between operators negotiating interconnection agreements after 60 days. The NTRC is also mandated to keep a register of disputes. Part 13, Tribunal. This part establishes a tribunal, and it is a new provision under the EC bill and serves to separate regulatory function from adjudicative function. This creates greater transparency as the Commission no longer investigates and still adjudicates. And I know, since assuming this role, this was one thing that the service providers always complain about. How can the same body investigate and adjudicate? And so now that is being rectified under the EC bill, so I'm sure they will be pleased to hear that. Part 14, miscellaneous. This part addresses a number of issues, including fees payable by service providers, inspection of records held by the NTRC, right of appeal to the High Court, repeal and savings conditions, transitional provision, and the regulation power by the minister, amongst other things. Mr. Speaker, given the speed of technological innovation in the electronic communications sector, the substance and content of the regulations for the sector need to evolve rapidly. The constant developments in the electronic communications sector necessitate some form of regulatory response. Therefore, the EC bill is the regulatory response needed to keep these new developments in check and will address the rapid growth and advancement in that sector. Mr. Speaker, I am also pleased to indicate that approving the EC bill to be passed into law in the Federation of St. Kitts and Nevis will have no direct cost implications for this government. Any cost-related matters have been budgeted for by ECTEL, including any costs related to the establishment of a tribunal under the EC bill and a public relations campaign in the Federation for public sensitization of the EC Act once it is passed. Mr. Speaker, I wish to draw your attention that under the current Telecommunications Act, there are at least 17 pieces of regulations and/or legislative instruments. As such, these will continue to be enforced until they are replaced and repealed by the new regulations under the EC Act. ECTEL will recommend these regulations and orders under the EC Act to the Federation, which will then require approval and subsequently need to be gazetted for its effect, as outlined in the EC bill. However, we understand that we can't do everything all at once, and so it will be done in a phased approach. Mr. Speaker, I respectfully request for consideration of the above on the EC bill and for the approval of its enactment. The EC Act We repeal the Telecommunications Act, the Telecommunications Act, yes, and will provide new legislative framework for the electronic communications sector once enforced. The Federation will make history also as being the first ECTEL contracting state to promulgate the new EC bill, which will transform the electronic communications sector. And so, Mr. Speaker, I'm asking for this bill, this history-making bill, as we move towards digital technology and digital transformation, and as part of one of the regulation and legislations that will be important to ensure that once we move to this type of economy, that we will be successful in doing so, and that all arms would be properly regulated and legislated. And this is just the first, Mr. Speaker, because I think it's important for me to also say that we should soon be introducing into Parliament for the first reading the Mobile Electronic Communications Roaming Services Bill, which CARICOM has indicated as priority for this year as well. So all of these, plus more regulations as we move towards digital transformation, would allow us to be able to achieve true transformation that we seek and ensure that we are successful at doing so. And so with those few words, Mr. Speaker, may it please you.